Supreme Court of the State of Colorado is now in session. Chief Justice Bowick presiding.
You may be seated. Thank you. Welcome, everyone. We are here for a special hearing with regard to implementation of a potential rule change. I am going to turn the helm over to Justice Birkencotter, who's our liaison to the attorney regulation, and she's going to captain the ship from here on out. So,
thank you, Chief Justice. Welcome, everyone. This is a public hearing on a proposed plan for implementation of the Licensed Legal Paraprofessional Program, or LLP program, as it is called for short. Back in June of 2021, the court asked the Supreme Court Advisory Committee on the Practice of Law to develop for the court's consideration a proposed plan to implement a program to license legal paraprofessionals like paralegals to provide certain types of legal services in certain types of domestic relations matters. The Advisory Committee's PALS subcommittee and its various working groups drafted a detailed implementation plan that outlines, among other things, what an LLP would be allowed to do or not do, how an LLP would be deemed qualified, and so on. The Advisory Committee voted unanimously on May 20th, 2022, to recommend that the court adopt the proposed implementation plan. The court subsequently voted to put the proposed proposal out for notice and comment. We published the letter from the Advisory Committee and its attachments, which included the proposed plan. The court also solicited written comments and set the proposed plan for this hearing. The court has received a number of written comments, and we thank you very much for those written comments. I'm not going to list the names of the folks who submitted written comments because we received so many of them, but we have reviewed them. We have a number of speakers who are here with us today. We have determined that the speakers are each going to have 5 minutes to make their comments. And with that, we are going to go ahead and get started. Our first speaker is Maha Kamal.
Good afternoon, Your Honors. I think I know everybody except Chief Justice Boatwright, so good afternoon.
good afternoon.
Thank you so much for all of your time and attention on this program. I am one of the co-chairs of the original subcommittee, and it's been an honor to serve and work with all of my colleagues, who I also thank for all of their work. I am specifically going to focus on the comments that were made by the Family Law section. I serve on the Executive Council of the Family Law section, as well as the Alternative Dispute Resolution Executive Council, and there were a few comments. We had 2 special meetings. They deliberated this, and they have their own subcommittee for PALS that's been serving under Dave Johnson for about over a year and a half. The 2 that struck me the most and came up a lot was that LPs are going to provide subpar representation and dilute the practice of law. And that did not sit well with me. It's very unsettling, particularly that this program is going to require LPs to go through extensive training, 1,500 hours, academic requirements, coursework that junior associates going into family law firms or hanging their own shingles don't even have to do. I know that when I entered family law, which is what I exclusively practice, I didn't have any of that experience. I had one of my wonderful mentors actually supervised me. And so for LLPs to be considered off the bat as subpar, I think is a little disingenuous. And so I did want to bring that note that they're probably going to be a lot more experienced and ready to practice than many junior associates. Similarly, the dilution of law argument. We are here to serve the people. We're not here to serve lawyers. I know that lawyers practice law and they clarify the law, they argue the law, but at the end of the day, we have to focus on how is the law serving the people. And the arguments that you've probably heard the most in terms of analogies are that this program is akin to a physician's assistant or nurse practitioner. And in the beginning, in the medical field, they face the same sorts of hostilities. And now many of us actually interact with them on the forefront instead of doctors when we schedule our appointments. And so I don't think it's a dilution of law. I think it's actually going to enhance and complement the practice of law to have LLPs by our side and to be able to refer out to them in the event that we encounter potential clients that are not able to pay our exorbitant exorbitant rates, which are anywhere between $200 to $500 an hour. There was some concern raised at the family law section comments that the LP rates are unknown. They are unknown in the state of Colorado because we haven't executed this program yet. But if you look to Utah, and the Utah rates were provided to the family law section, they're seeing anywhere between $50 to $125 an hour for LPs, which is substantially less than what lawyers are charging. The implementation costs, similarly, we don't have that data because the program hasn't started yet. I hope it does. But the cost of litigation and the cost and demands and stress that the unrepresented litigants are putting on the judicial system right now is exorbitant. And I would venture to say that that's probably costing us more to not have more adequate support for unrepresented parties than the implementation of this program. And I really hope that we do move towards that direction. The complexity argument is also coming up a lot, that the cases are way too complicated in family law. Well, they are complicated to an extent, and we have 70 to 80% of litigants trying to navigate the system by themselves on these issues. I just volunteered this morning for the Metro Volunteers lawyer for an hour, and I talked to a woman who is disabled, and she just almost broke down in tears when I started rattling off all of the JDF forms that she needs to fill out. And she can't afford, on her SSI, she cannot afford an attorney. She can barely afford unbundled services, but she could afford the $45 rate, the one-time charge for a process server. And that's in the same range as where she could get an LLP to at least help her out, even on an unbundled basis for that. And so the complexity argument, my counter argument to that is that these people can't afford to make their cases complex. They don't have enough money. They don't have enough money for experts. They don't have enough money to get lawyers involved, and a lot of them are going to be non-contested, and I can speak to that personally because I do unbundled services exclusively and sliding scale. So I deal with a lot of cases in which the other side is unrepresented. Similarly with arbitration was the other argument, and I'm running out of time. Their parent coordinator decision makers are big arbitrators in family law, and a lot of them are not attorneys. And so that argument that LPs can't be arbitrators, I think just fails on its face. So I think I'm out of time. Hopefully I got through most of those arguments, and I appreciate your time, Your Honors. I hope we can move this forward.
Can I ask a quick question?
Sure.
Thank you for being here, and thank you for your work, and nice to meet you. In looking at it, what do you think I guess in Utah, how much has it impacted the unrepresented?
It's working, Your Honor. I think even if you look to Washington, which unfortunately sunsetted its program for other reasons, they were venturing out into other practice areas, which did not work out too well. They've kept the program because these licensed technicians, licensed paraprofessionals are helping law firms, and they're staying in business. A lot of them have actually hung their own shingles in Utah, and Utah has continue the program. So I think it is benefiting, Your Honor. I don't know, we would have to do a lot of outreach to make sure that Coloradans know that this is an option as an alternative to law school. But, with the press that I've interviewed with, Colorado Matters was interested in this. I just got phone calls from people from around the state that were so excited to apply. So I think there's a lot of opportunity there and a lot of service.
All right, thank you.
May I ask a procedural question? Good afternoon, good to see you, and thank you for all the work here. Just procedurally, there are a whole bunch in all the comments, we got a lot of suggestions for change and amendments and the like, and if you want to pass this to one of your colleagues, that's fine. What's the next steps? I mean, after this hearing, what do you go back? So what happens next?
Well, the next steps is that Your Honors are going to approve the program. And after that, we have a lot of work to do, but we have a wonderful sister state next to us. Actually, I would say venture with Arizona to help us out with this, but they've done a lot of the groundwork in establishing the details for the bar examination. We have to, identify statutory upgrades and amendments, looking at the rules. We do have a rules committee from the implementation program that's been working on this. So we anticipate a lot of the specifics are going to be addressed next, and we're going to bring on a lot more professionals to help with that. And it's probably going to take at least a year, if not, that's a little ambitious.
And so at some point, assuming this gets approved, you'll come to us with proposed rules and...
Absolutely. And those are in the works, Your Honor. They were in the works for the past year. We've had a wonderful team for the rules working group that's been working on that. But to finalize all of that, those are the next conversations we'll be having.
Thank you.
Any other questions? Thank you, Ms. Kamal.
Thank you, Your Honors. I appreciate it.
Our next speaker is David Stark.
May it please the court, I want to thank you for giving us the opportunity to speak with you today. I am here speaking on behalf of the Advisory Committee and also on behalf of the Access to Justice Commission as a member of the Access to Justice Commission. That commission recently adopted a resolution encouraging this court to adopt the implementation plan. This implementation plan provides a method of producing and regulating licensed legal paraprofessionals that are well qualified and that can give legal advice and counsel in less complicated family matters to those who now attempt to represent themselves. This is really the client population that we are looking to serve. I think as we all know, there is a justice gap in this country. There are those that qualify for legal aid that are at 125% of the poverty level, and there are those that can hire lawyers. And approximately 60% of the population is in that justice gap in between. They can't afford lawyers at regular rates. They try to represent themselves, and this creates problems for them, and it also creates problems for the system. And so we're hoping that this business model will provide legal advice to that 70% of the family law parties in Colorado that try to represent themselves. They go without lawyers. And over 70% was the number in the last several years. What does this do? Well, number one, it denies access to these folks. But number two, it also dilutes the quality of justice for everyone else, people that have lawyers. These are not indigent clients. These are clients that can pay something. But they can't pay regular lawyer rates. And so we would hope that these folks would use alternative billing arrangements, lower hourly rates, and unbundled services, as Maha Kamal has mentioned. As I said, these self-represented parties slow down the system and they interfere with the judicial system. If you speak to judges on the trial court bench, clerks, court personnel, they're all happy to tell you how they are forced to give some guidance to these self-represented litigants, but trying to avoid giving legal advice, which they're not allowed to do. And considering how much time is devoted to these parties while others must wait, you can see how this dilutes our justice system. Now, what about pro bono? I know that some of the comments say that, gee, pro bono is the solution to this, but we have 47,000 self-represented parties last year in domestic cases in Colorado. There simply isn't enough lawyer time or lawyer inclination, frankly, to handle all of these cases. These LLPs will be well qualified. They will be regulated. They will be required to satisfy educational requirements, experiential requirements, and a licensing exam and an ethics exam as well. One item that I think is important to note is the difference in cost. For an LLP to obtain an accredited paralegal certificate, a 2-year program at an accredited institution in Colorado, like a community college, the cost is $9,000. Contrast that with the cost of $140,000 to get a law degree at the University of Colorado or the University of Denver. You can see why these folks will have the ability and the capacity to make a decent living and yet charge much lower rates, which are much more affordable for this client population. I think this is a program whose time has come. We see this type of program advancing all across the country. There are many other states that have adopted it: Utah, Arizona, Washington State. Oregon now has approved a program, and we believe that this is the future for bridging the justice gap. And we would hope that this court will choose to do that by authorizing the implementation of this program.
So, Mr. Stark, good afternoon. Thank you for all your work on this. I'm wondering, having read the comments, whether any of them give you heartburn or whether you think any of the suggestions made in terms of perhaps making amendments deserve some merit.
Well, I think that you could certainly take a look at the cap that we have proposed. We have proposed a cap of $200,000 in net marital assets. Now, maybe that's too low, maybe that's too high. That's something to be considered. The idea here, though, is to give these LLPs an opportunity to handle uncomplicated cases. How do you measure uncomplicated? Well, one method is to consider net marital assets and perhaps income. But there may be other ways to measure how complicated a case is. But the idea is to give these folks the opportunity to handle these kinds of cases. And there are many folks that come into the courthouse and they simply want to get divorced, and they don't have a lot of dispute, but they want to see that it's done right, so that 3-4 years from now, somebody doesn't say, well, you really didn't get divorced because you didn't do it right. And these things happen. So I think that's one thing that could be considered, is how we measure what's complicated. The other is that this is not something that will compete with lawyers and with lawyers' practices. Lawyers are not serving this client population now. If they were, we wouldn't have 47,000 self-represented litigants in domestic cases. And so, I think that the idea here is that the client population that we're looking to serve are folks that are trying to represent themselves.
Mr. Stark, let me add my thanks to the many others that have been shared. As we look at this body of work, it's pretty extraordinary. And so thank you and all the folks who've labored so hard to help bring this to fruition. I have a question about efficiency in the courtroom, to which you alluded. So if you as I understand it, an LLP will not be allowed under this scheme to actually advocate in the courtroom on behalf of the client. And I just think that sets up for situations that are going to be very frustrating to the trial judge, who can see that there's someone who has the knowledge to be able to do, much more effectively communicate the client's position. But what that person is going to be forced to do is to pass notes and to whisper to the person about how to do it. And I suppose the scheme does allow the trial judge to ask questions of the LLP, but I worry that could sort of devolve into some kind of charade where the judge kind of lets this thing go on in an unwieldy way and then just asks a bunch of questions of the LLP in order to get to the gist of what the client seems to be after. Surely you've thought about that. Can you?
We have, and I think that the answer is that if a case is going to go to trial, if they're going to have a hearing, a permanent orders hearing, that's the time when the LLP needs to advise the client that you need a lawyer to handle the hearing. And we have unbundled services in Colorado, and there are many lawyers that will provide their services for a deposition, for a pretrial conference, for a permanent orders hearing, and they can do it that way, and they should. I don't foresee the situation where you're going to have an LLP sitting there and a lawyer on the other side, and the LLP is is simply unable to do anything.
Well, under the scheme, as I understand it, right, the LLP would not be allowed to advocate in the way that a lawyer would in that setting, right?
That is
So
correct. But the LLP would have a duty to advise the client that for this particular service, you need a lawyer. And that would be part of of our rules. I think our proposed rule now 1.1 requires that. And so the LLP would have that obligation.
And not to belabor the point, I realize we have many speakers, and my colleagues are probably already wishing that I would just be quiet. But I'm just wondering, whether there are going to be many simple cases where it would just make sense to allow the LLP to actually speak up in the courtroom. And what's the principal distinction between some of the things they're going to be permitted to do and some of the fairly straightforward things that they won't be allowed to do? I'm just struggling with that. How did you decide to reach this boundary of no speaking in the courtroom?
Well, again, I think it goes to the issue of complexity, and also I think we looked at other programs around the country, and I know the first time I heard about this type of restriction was with the New York Navigators program, and in that program, the LLPs are allowed to sit and stand with the client, but not to address the court, not to examine witnesses. And I think that's probably where it came from. Now, our proposal is certainly a modest one, and it's much more modest than other states. And I could see this program being implemented where the LLPs could address the court, could examine witnesses, again, in uncomplicated cases.
Thank you.
Can I follow up on that? So there are a couple of really key differences between this proposal and what a number of other states have done. You just touched on one. A number of states do allow licensed paraprofessionals to advocate in court. Another one is that a number of other states do require some sort of affiliation with an attorney for licensed paraprofessionals, either supervision by or at least affiliation with. How would you feel about that as an amendment to the proposal? Do you think it's essential that they be permitted to be independent?
Well, I think that there are a couple of states that requires lawyer supervision, not all. And I think that's fine, except that if you have LLPs working solely in law firms, then their rates are probably going to be higher. And so there won't be as many of these self-represented litigants that can be served by these folks.
So that would kind of defeat the purpose.
Yeah.
Any other questions? Thank you, Mr. Stark.
Thank you.
Our next speaker is Rebecca Failer. And if I have mispronounced your name, please let me know.
Actually, I'm quite impressed. You pronounced it correctly. Many people say faller, and then I always have to say it's Failer, like trailer, but with an F sound. So thank you. Good afternoon, and may it please the court. My name is Rebecca Failer, and I am the supervising attorney of the Family and Children's Unit at Colorado Legal Services. I requested the opportunity to speak today to specifically address the comments I have heard from various opponents to the creation of the LLP position, that instead of creating the licensed legal paraprofessional opportunities, we should instead increase funding to CLS so that CLS can fill this access to justice gap and assist the litigants who would otherwise seek the assistance of LLPs. While these comments are certainly well-intentioned, and while increased funding to CLS is always appreciated and necessary, this would frankly not fix the problem that the creation of the LLP positions is intended to address. The unit that I supervise serves survivors of domestic violence who financially qualify for CLS in divorce, custody, and civil protection orders throughout the Denver metro area, which includes Denver, Jefferson, Arapahoe, Adams, Douglas, and Elbert counties. My unit that serves all of these counties currently consists of 4 attorneys, including myself, and 1 paralegal. CLS does have offices throughout the state that provide assistance in family law cases, but my unit is the only office or unit of attorneys at CLS that specifically focuses on contested family law cases. Colorado Legal Services receives the majority of its funding from the Legal Services Corporation, or LSC. LSC is a publicly funded 501c3 established by United States Congress. LSC is funded through the congressional appropriations process. Per our LSC funding restrictions, we are limited to providing assistance to individuals who are at or below 125% of federal poverty guidelines. With some limited exceptions, we can sometimes assist individuals with LSC funding who are up to, but not exceeding, 200% of federal poverty guidelines. Now, even those who don't follow politics closely may understand that increasing funding through the congressional appropriations process is neither quick or easy. The idea that it would be a simple thing to increase CLS's LSC appropriations such that we could represent all income-eligible individuals who seek our assistance in family law cases, and therefore we wouldn't need the creation of an LLP program, is just not realistic. Colorado Legal Services LSC appropriation from fiscal year 2022 was approximately $5.7 million. Our 2023 fiscal year appropriation request is approximately $15.5 million. For fiscal year 2022, out of 699,596 eligible individuals, CLS was able to serve 13,740. With our LSC appropriation as is, and even considering other grants CLS receives, we are not able to even come close to meeting the needs of all income-eligible Coloradans who seek our assistance with civil legal issues, let alone meet the needs of even the folks who come to us seeking only assistance with family law issues. Our small but mighty unit of 4 attorneys covering the entire Denver metro area just can't even come close to serving all of these needs. And even if our unit were to double in size due to increased LSC funding, we would still not be able to meet that need. It is just too great. And no matter how much Congress may increase our LSC funding, we would still be limited to assisting only those individuals who meet the strict income criteria set by LSC. This shuts out a huge percentage of the population of Colorado that need assistance in family law cases, but cannot afford to hire private counsel, but may perhaps be able to hire an LLP to guide them through their case. So again, while I am by no means saying that increased funding to CLS would not be helpful or necessary so that we can serve more income-eligible individuals, the bottom line is that increasing that funding and expanding our units or expanding the number of people we can serve would absolutely not address the huge access to justice problem that creation of the LLPs is intended to help ameliorate. And I am out of time. Thank you, Your Honors.
Any questions? I'm sorry.
No, that was very elegantly done. I think it would be disservice to ask her any questions without. Thank you.
Thank you. Our next speaker is Amy Gosha.
Good afternoon. May I please the court? My name is Amy Gosha, and I'm a family lawyer. I've been practicing for 15 years. And my perspective today that I would like to bring to you is that I've been able to practice in the rural areas in the Vail Valley and also in the metro area. I am in support of implementing the LLP program. I became involved when Judge Arkin reached out to me when I practiced in Vail, Colorado, and she asked me specifically about the net marital asset cap and what that would look like
in a rural area. And at the time, I felt that 200,000 was a sufficient amount. Since that time, that was in 2020, we've seen the real estate market fluctuate. So that has gone up and down. And so when I was reviewing the 88 pages of comments that were provided, I really liked Judge Arkin's comment regarding if you have a case where there is, for instance, a marital residence. If there's not liquid assets and there's a dispute over what that asset is valued at, an LLP should be able to proceed in that matter if there's a dispute over that amount, even if it goes up to 300,000. So I liked that perspective, and I would suggest that the court look at that. Also regarding the concern regarding the gross income cap, I think that 100,000 for people who are not married and dealing with allocation of parental responsibilities matters is the right income cap to consider. Another thing about my firm that is unique is that we constantly look at the practice of law and how it's evolving. My firm, we do represent very high-end clients, but we also do other forms of services. So we offer limited scope representation. We also offer flat fee services for divorces. And when I look at the business model, just from an owner of a law firm in a rural area and the metro area, I really see the LLP as an asset to my firm. I really see that an LLP could help people that I'm not able to help, and that my paralegal is not able to help. So I think that the place for an LLP in the law firm would be a great thing. Another piece that I would like to touch on is that in reviewing some of the concerns, there were some comments about diluting, the practice of law. And what I can say is that the planning committee really took to heart, how you define what is complex in a family law case. There's not a metric or a way to actually say what is complex. I think we can all sit here and say that family law cases are complex, no matter what your situation is. However, I think besides looking at the net marital asset cap and the income cap, I think also what we did is we carved out specific areas that would cause complexity, such as if you're dealing with a case for trust, an LLP would have to advise a client that they cannot handle that matter. I also see, and this happened a lot because I practiced with limited scope, where a client would come to me, would try to fill out the paperwork, and then it ended up in a litigated situation, and they would hire me to come in just for the hearing. So I do see that connection between an LLP working with a lawyer who is limited scope working really effectively. One comment I also saw throughout the 88 pages was a concern with LLPs drafting qualified domestic relations orders. I agree with that concern. QDROs require specific knowledge regarding government regulations, and so it is highly recommended that a qualified professional draft those. So I would consider that. As far as the scope of work expanding beyond family law, there were some comments regarding that. I do see this program, after it's implemented, being able to be expanded into other areas. I do like the fact that it started with domestic relations, but I could see that happening in the future. I also agree with what Dave Stark said, that the LLP's ability to orally advocate in court in uncomplicated matters could be something that we implement down the road. And to your Justice Hood's comment, I do agree, it could put the litigant in kind of frustrating place in court. So I could see that down the road.
I was more worried about the judge, but I'm sure it would be frustrating for the litigant, too.
Yeah, I guess my perspective being a lawyer, representing, so I do agree with that comment, and I'm out of time, so thank you.
Scotia, may I ask a question? Given, I know you work at a firm up in the mountains, one of the things that when the Access to Justice Commission did its Listen and Learn tour last year, the feedback that kept coming in was in small communities, we would really need, this would be most helpful if it wasn't confined to domestic relations, if there could be licensed paraprofessionals who could help with whatever the problems were.
Correct.
You say you think that this could be something we could look at after a starting period. What do you think the purposes of the starting with one practice area would be?
I think I based that off of my comment more on what was important in looking at the history of this program, because, the program first was focused on landlord-tenant. So I was basing it more on just, I guess, opining on that, the biggest need that we see right now is in domestic relations.
Other questions?
Yeah, I do have just a question about the $100,000 income cap for APRs. You said you thought that was appropriate. I think the report itself dropped a footnote that questioned whether it needed, maybe that could be tweaked in some way. So why do you think $100,000 is the right number?
I think that just anyone who makes $100,000 or less probably is going to not be able to afford an attorney like me at my hourly rate. That's kind of my anecdotal answer. But I do think with inflation, that's a real thing that we're looking at in cases and how that affects people's ability to, purchase certain things, including legal services. I guess I would say that's very akin to, maybe you could look at maybe a range. Actually, with income, you're probably not going to be able to look at a range. It's going to need to be like a fixed number. But I do think carving in, I guess, a review period on whether or not that income amount should be raised at some period of time would be helpful.
Thank you.
Thank you, Ms. Gosha.
Thank you.
Our next speaker is Angie Arkin. Judge Arkin.
May it please the court. Thanks so much for asking us to do this. You all have been so thoughtful about access to justice in Colorado, and it's so appreciated. I will tell you that my former colleagues, I still consider them to be colleagues on the judiciary, are really struggling in the area of domestic relations. So your request that they receive some help, and I see this as significant help for the litigant population, but also help for the sitting judges in domestic relations and magistrates and family court facilitators and Sherlocks. This program is just an enormous positive for them. It will also help practicing lawyers because, as Mr. Stark mentioned, judges aren't going to be sitting in the courtroom with the litigants filling out the sworn financial statements and those sorts of issues. Justice Hood asked the question about efficiency in the courtroom. So currently, as I know you will remember, the
Long time ago now.
the pro se party struggles to advocate. And usually it's the judicial officer in the courtroom who's asking questions of that litigant in order to get the case resolved. If an LLP is sitting next to that individual, even if they can't afford an attorney unbundled to litigate, if the LLP is sitting next to that person and helps them identify the form or the document or assist them with responding to the court's questions, that will be a significant step forward in terms of efficiency of the hearing. The LLP may also be able to be sort of an interpreter of legal speak to the litigant while they're sitting there. The judge is asking you for this or that, or something along those lines. What Mr. Stark was talking about with respect to lawyers and LLPs, those of you who've sat in domestic, and there are a few of you up there, remember 1410-119, which allows the court to provide attorney's fees in advance to the other side if what we're talking about is a higher asset case. So we're not really looking at situations where there will be an LLP on one side and a lawyer on the other side very much. Those cases will be rare because we will hopefully be training the judiciary to level the playing field when there is money to do so. And the complexity of the case warrants having lawyers who are trained in this area or who are knowledgeable in family law participate. We particularly did not make the cap any higher because we wanted to assure that we were not taking work away from lawyers. That was the purpose. We are the only state that I am aware of that has a cap. And we did that purposefully to assure that the practice of family law for the lawyers who are practicing it continues in a positive way. This would be assisting those people who haven't hired lawyers, who aren't hiring lawyers, and who probably, given the opportunity, even if there was more unbundled, wouldn't hire lawyers. Judge Taubman was the primary source of the point about if there is equity in the marital residence and the litigant can't access that equity for the cap, then having a cap can be problematic in terms of limiting the number of litigants who have access to this assistance. So the comment that I made was primarily if you have a situation where there are net marital assets of about $200,000 or less, and I apologize, I'm out of time.
Please finish your statement. I'd like to hear the rest of it.
Okay. So if there are net marital assets generally of $200,000 or less, and the LLP has the individual in their office and they're saying, yes, I can assist you, and then the other side says, no, the house has more value. If every case required a judge to say, yes, LLP, you can continue to represent the individual, that would be a lot of judicial time. And my concern would be if what we're talking about is a difference of opinion about an asset that's hard to value, then maybe there should be some discretion related to that for the LLP to continue in the case if that's the issue. So.
Judge Arkin, I'm curious about your perspective as someone who used to preside over a domestic relations docket, as somebody who has mediated lots and lots of domestic relations cases. I think we all know that, I'm going to make up a percentage, 90% or 95% of cases actually resolve long before anybody ends up at a permanent orders hearing. What is the impact of this proposal with respect to that piece of domestic relations work?
LLPs should significantly reduce the number of folks who have to go to court at all. Recently, I was working with a brand new judge doing some training, and it took me over an hour just to explain to the new judge, who is a brilliant individual, how to fill out a child support worksheet. Because the legal complexity of what you put into each of the blanks is so complicated. and explaining why it's complicated. So many self-represented litigants find the forms themselves daunting. They are terrified about filling them out, and so they wait until they get into the courtroom to fill them out, which so many people who could talk to each other long before they get to a courtroom and use mediation much more effectively would be assisted by these folks in these lower, less complicated cases. Keeping in mind, domestic is always complicated, as I think it was Ms. Kamal who mentioned. That being said, right now, it's just the folks themselves who are struggling with this.
So is it fair to say the hope is, in any event, that with the assistance of that kind of expertise that costs less money, though, you're going to have more people that are going to be able to solve their cases either before they get to mediation or at mediation, and thus taking up less court time?
Resolve their own family issues together as a family, or as two families going forward, which is what we want everyone in domestic to do with the assistance of counsel or not.
So Judge Sharkin,
Yes, sir.
your view is, and thank you for all your work on this, by the way, but your view, as I understand it, is that with LLPs, there are going to be less opportunities or cases in which pro se parties find themselves in the courtroom. But to the extent that that happens, having an LLP available should make things more efficient, even if they can't directly address the court.
Yes, that's absolutely true. And I also anticipate that these paralegals, who are wonderful folks, or paraprofessionals actually, will also do some pro bono work. They will be required to do CLE and encouraged to do pro bono just like lawyers. So maybe they also will be at the pro se center at the courthouse, assisting those litigants who come in for their hearing that day in filling out whatever is necessary to augment the work of the Sherlocks and the FCFs.
Reminds me a little bit in the criminal scenario, and it's not a perfect comparison, but advisory counsel. If you have a pro se defendant and they have an advisory counsel, even though advisory counsel can't really directly address the court, it tends to make things more efficient for the court just to have that person there for the pro se defendant, assuming the pro se defendant wants that assistance, wants that help.
That's a wonderful way to think about it. We talk about nurse practitioners or PAs. We're not trying to create a profession that is a better alternative to a lawyer. We are trying to create a profession that assists people who aren't getting assistance at all. And that's really the focus of this. Thank you.
Thank you. Our next speaker is Laura Landon.
Good afternoon, Your Honors. My name is Laura Landon, and I'm a paralegal with San Vigiano Kansas PC. I've been working in family law for 13 years now, and I'm a member of the Rocky Mountain Paralegal Association. Over the last year, I've had the honor of being involved with one of the PALS subcommittees. I've also had the opportunity to speak with the paralegals of the Rocky Mountain Paralegal Association and about this exciting new career path and the immense help it will provide. I intend to be one of the first to sit for the LLP licensure exam, and I'm excited to see this very necessary profession come to the state of Colorado. And I apologize for any redundancy. I don't trust myself to go off script. And I know this comparison has been drawn, but I do often make the comparison with what the nurse practitioner has brought to the patient care in the medical field and what the LLP can bring to Colorado families in the legal field. The assistance we'll be able to provide to people who would otherwise go without any legal aid will be invaluable to both the litigants and the courts. And just as a nurse practitioner sees patients of all different backgrounds with certain limitations, the LLP can similarly provide help to a broad demographic. This is what I wanted to speak briefly about, is who is the LLP's client. I believe the LLP is intended to help both the modest and average earning citizen who cannot afford to hire a $300 to $400 an hour attorney or have multiple thousands for a retainer payment. The reason I wanted to highlight the broad income range of this demographic is because some have suggested that an alternative to the LLP is to simply require attorneys to contribute more pro bono hours. I respectfully submit that this would not provide a solution. The population we're looking to help does not often qualify for Metro volunteer lawyers or any free or reduced cost legal aid. A significant population doesn't qualify for aid, but also can't even contemplate spending the multiple thousands of dollars it costs to hire an attorney. In fact, the very people I hope to assist as an LLP are those just like myself and my peers. It's my hope that the courts and the public see the LLP profession as more than a secondary option for low-income families. Yes, the client includes people of modest means, but there's a benefit to allowing LLPs to assist at any level. It's important to note that the client is not someone who's choosing between an attorney and an LLP. The potential client is someone who's presently faced with the option of having some help from an LLP or no help at all, and at a reasonable rate. They should be given that option and allowed to make an informed decision as to obtaining limited or even unbundled services to meet their needs and budget. It's a shame so many are faced with choosing to go it alone or liquidate their assets just to fund an already traumatic time in their lives. I'd like to identify one of the barriers to the LLP's ability to serve this demographic, and that's the $200,000 asset cap. It's my hope that the court will consider either excluding real property in the asset cap or looking at ways to limit the LLP that are not directly tied to assets or income. As presently drafted, I would not be permitted to represent myself or anyone I know who owns a home. I would respectfully assert that LLPs can be limited in the scope of the cases they take without being hamstrung to that degree. An alternative to limitations based on assets or income would be to restrict the LLP based on case complexity. I respect the need for guidelines that protect individuals with complex family needs. I agree that LLPs should be limited to working on simpler cases. But assets or income alone do not result in a complex case. An LLP could offer a great amount of help to middle income earners with W-2 wages and assets that include a home. The LLP should be permitted to offer services in any non-complex case, such as those which do not require expert witness testimony, do not involve business valuations, and uniquely tailored asset divisions, or cases which involve significant debt. A determination of complexity does not need to be tied to assets, as this only serves to rule out a large portion of the pro se parties currently needing legal guidance. I hope the court will make a way for experienced domestic law professionals like myself to offer aid to those of both modest and average means. I can assure the court that an LLP will take pride in their profession and will refer cases that are beyond their skill and experience to a qualified attorney. And there's my shot clock.
Thank you.
Thank you.
Questions? Thank you. Our next speaker is Natalie Knowlton.
Good afternoon. May it please the court. My name is Natalie Knowlton, and I am a Colorado lawyer and the Regulatory Innovation Advisor at ILS, the Institute for the Advancement of the American Legal System. ILS is a national independent research center housed at the University of Denver and dedicated to continuous improvement in the civil justice system. I spent many years while serving as ILS Director of Special Projects studying the self-represented litigation issue, including direct research and interviews with self-represented litigants themselves. And I'm here today to speak in support of the Licensed Legal Paraprofessional Program. I commend the Colorado Access to Justice Commission, many who are here today, and the Colorado Supreme Court for joining the growing ranks of judicial leaders who are calling for innovation in the delivery of legal services. The time has come, and this court is a pioneer. Dockets full of parties without lawyers are no longer anomalies. It is just the business of our courts today. And when we talk about this new normal in our family courts, we often discuss self-represented litigants as one homogeneous group. These individuals share a status of being unrepresented, yes, but this is generally where that commonality ends. The sheer lack of affordable legal services is a considerable issue for many, but that doesn't paint the full picture. In 2016, I conducted interviews with almost 150 self-represented litigants in family cases, including up in Larimer County District Court. We uncovered through these conversations that the decision to self-represent is nuanced and multifaceted. And there's an element of consumer choice in this calculus. Some people have confidence in handling the matter themselves. Some people believe their case is straightforward enough to do so. In family law matters in particular, the reality that we learned through these individuals is that some people fear hiring an attorney because it will make the process more adversarial. And some just don't want to pay a lawyer's fee. These diverse individual preferences are not inconsistent with a desire to have some degree of legal help in one form or another. I raise these issues because I believe it is important to remember that people may be attracted to this program for a variety of reasons, including, but absolutely not limited to, the price point at which these LLPs will be operating. And I think we should be comfortable with that. This program is not a subsidized legal services program, but it is without a doubt an access to justice initiative. It cannot and should not be viewed only as a solution for low-income individuals, because the economic viability of this program depends on consumers who have some degree of purchasing power. And it's on this point that I offer a suggestion, if I might, as the program moves forward. These new providers will be charging a lower rate than attorneys. We suspect that, but they will nevertheless be charging. And I'm concerned that the program limitations, the cap on marital assets, will exclude many consumers who can or want access to services at this price point. Let's consider some background demographics of Coloradans. In 2020, the rate of home ownership in Colorado was 66.5%. According to census data, between 2016 and 2020, the median value of owner-occupied housing units was approximately $370,000. These are homeowners who may not be able to afford that house today. These figures illustrate the extent to which this would be disqualifying for many separating and divorcing families. More research. Just a few weeks ago, 9 News Colorado reported that the divorce rate for the over 50 age group has doubled, despite the overall nationwide decline in divorce. Colorado has one of the highest rates, with Denver having the highest. This average retirement savings for those between 55 and 64 is approximately $256,000. For those over age 65, they're saving on average $280,000. That, by the way, is not enough for most people to survive on in retirement, given projected income levels and rising inflation costs. These figures also illustrate how another sector might be priced out of this program. The National Center for State Courts has worked in the area for triage for domestic cases and has found that non-monetary factors are far more determinative in case complexity. For example, the level of agreement reached between parties, or alternatively, the degree to which parties can and are willing to work together to reach an agreement. These have been found to be particularly important. The Alaska Early Resolution Pilot Project has found something similar. In conclusion, if once implemented, this program suffers from a lack of interest on either the provider side or the consumer side. Before declaring failure, I suggest this court and others look critically at the program requirements, and in particular, this monetary cap. There are sure to be several iterations of this program before it finds that crucial product market fit, and I look forward to seeing this move forward. Thank you for your time and your consideration today, and thank you for being leaders in defining how the legal profession serves the public. May I answer any questions for you?
If not that cap, then what would you propose?
I, speaking on behalf of myself, would propose no cap. I firmly believe that parties should be able to opt into this whether or not they make a certain amount of money and whether or not they have a certain amount of marital assets. I personally get a little uncomfortable when I think about regulators and those who they are regulating making decisions for consumers on what they have to afford in order to achieve justice.
Thank you.
Thank you.
Thank you.
Our next speaker is Michelle Clark.
May it please the court, thank you, and good afternoon. My comments will be brief and a little bit of a sideways glance, I think. My name is Michelle Clark, and I am the president of the Mediation Association of Colorado. We are the statewide mediation association for professional mediators, and we're very interested in this committee's work. We have always been involved in conversations about access to justice. And the main reason I think that we were motivated to come speak today is because of I'm not sure if you understand the impact of what it is to read work created by the Supreme Court and committees of the Supreme Court that understand mediation, that value mediation, that recognize the role that mediation plays, not only for underserved litigants, but for all litigants. And so when we looked at this implementation plan and proposal, we were thinking, how does this affect our members' ability to mediate? And I don't know, I'm sure that you have all participated in mediation as a party, as an attorney, as a mediator. And if attorneys were as well trained and prepared to assist clients in mediating as it appears that the licensed paraprofessionals may be, I would be incredibly hopeful about the results, because what is conceived is an expansion of the party's ability to effectuate their own self-determining decisions. In other words, it seems from our perspective that this type of a program, this type of an option for people is going to make mediation more effective, because they are going to have better preparation, they will have a greater voice, they will have more knowledge of their rights, and mediators won't be put in that really uncomfortable position of wanting to help and being stopped by that barrier of advocacy. We cannot cross over that barrier and in suggesting solutions. And if there is available a lower cost option for people to bring with them to mediation, it really is going to make better for the parties. And as you know, people who mediate their agreements stick with them more often. Even people who mediate and don't reach an agreement are better prepared when they go to court. So they're going to hopefully be more mindful of the efficiencies of the system in that way. So I wanted to keep my comments short, but really do express appreciation for all of this work and our excitement as we see it going forward. I'm happy to answer any other questions that you might have.
Thank you.
Thank you.
Our next speaker is James Bailey.
Good afternoon, may it please the court. My name is James Bailey. I'm an attorney. I'm licensed to practice law in the state of Colorado, and I've been doing primarily family law for almost 30 years now. I primarily do complex family law cases. I do big asset, big divorces. And so I'm trying to give you a different perspective as I approach what this issue is. One, I strongly support this. I'm the guy who picks up the phone, who hears the tale from somebody, and I have to say, you can't afford me, you can't afford my brethren. You're not going to qualify for Metro Volunteers, or congratulations, you do qualify, you'll never get into the program. And this is an opportunity for that individual to have some form of representation going forward. And that's crucial. Everyone who has stood up here has said, family law cases are complex. They're filled with an emotional complexity, and they're filled with a financial complexity that requires some assistance to unwind. Sometimes that assistance is through the judiciary, whether that's going to be Justice Hood or former Judge Arkin. Sometimes it's going to be through just a wing and a prayer, and I'm suggesting that we stop that. So I'm here really to talk about two different concepts. One is complexity, and I dread the question that's going to be coming from Justice Hood here, which is the question of complexity. We're saying here that we don't want LLPs to be doing complex or complicated cases. What is that threshold? And I'm encouraging the court to not adopt a paradigm that says it's a net $2,000 marital estate, because there's really two problems with that. One is the former marital residence is very likely to have a value that's going to exceed that number. So please, let's exclude that from what we're considering if we're just doing an asset complexity. Two is the word net. Please remember that debt is also complicated. And so as you're approaching whatever that threshold is, when we're going to say that we need to have an attorney involved. Those are the considerations that I give. So what I'm suggesting is value is not a proximate, is not a proxy for what complicated is, nor is income. Especially as we're evaluating APR cases, we're saying that income might be a proxy there. But the real complexities that are associated with APR cases and the real questions that pro se parties want help with, not necessarily income. It's really doing parenting plans that are intended to work and are going to survive. I have some specific suggestions. I know that there's a proposed rule, it's Rule 2 is what I'm going to focus in on. And as you approach Rule 2E, I think that there needs to be an express definition of what a complicated case is or what complex is. And so I think that what it should be saying is that LLPs can't do complicated cases, and complicated cases include but are not limited to. I would be suggesting that that would include motions to be restricting parenting time, motions to remove a minor child from the state of Colorado. I apologize, I did not put this in a writing, but I think that the word in 2E that's using the word prenuptial agreement, whoever is hearing me, please use the word marital agreement so that it's consistent with 14.2.301. And I also want to encourage that all forms of contempt are complex. I recognize that a criminal contempt was carved out because in part of the potential for jail time and punitive sanctions. I assure this court, as someone who regularly tries contempt cases, that remedial contempt, which is a civil contempt, one, can involve incarceration and candidly is more difficult to prove than a punitive contempt case is. I would carve both of those out. Second is a question of competency. I think I'm a good attorney. I think you can hear me be arrogant on that issue. And yet consistently I am presented with questions that I'm not competent to answer. People come to me with bankruptcy questions or they come to me with taxation questions. And I'm smart enough to say, that goes beyond my area of ability, try somebody else. And I think it serves us well to remember that level of complexity and that answer is what we're looking for the LLPs to say. As they are approached with a bankruptcy question, because we have too many debts here and bankruptcy is an appropriate consideration, I can't do your case. It's better served and you're better served by somebody else. And in particular, I speak from a position of knowledge. You heard Ms. Landon speak. Ms. Landon's my paralegal. She is the best paralegal in the state of Colorado, and she is more competent than virtually every single attorney that I practice with on a regular basis. The opportunity for her to be of service to people and the Colorado families is a tremendous opportunity. My time has expired. I'm happy to answer any questions that the court may have.
Can I follow up with the debt? I mean, I did domestic, and it always felt like, I don't know whether marriages go bad because they go in debt or they go in debt because the marriage is bad, but it seems like there's always overwhelming debt. How do we weigh that into the complexity? Because, you know, we're talking about that net amount. I just always felt like it was, how do you apportion that?
There is a level, the magnitude of debt is directly related to what I would consider to be complicated cases. As you're approaching it, I agree with you that a given case is more likely, well, that's not true, a marriage is more likely to fail if there are significant debt issues. And so we're always presented with how do we unwind it and what are the complications that are with it. To me, the question isn't necessarily the debt itself. It's the form of the debt that underlies it. If we have a marriage where we're approaching, let's assume $100,000 of credit card debt, that's not an unreasonable solution. It's fairly easy to treat that as a negative property division and to say, hey, we have to allocate that between the two people. What concerns me more with the debt is when we're into different forms of debt or debt that might be associated with familial debt, where we're associated with a debt that is owed to the IRS, all of these other forms of debt that can render a case in and of itself difficult. And so I'm trying to suggest that in the concept of net marital estate, that we perhaps are talking about also having a definition of, here's an asset limit. Here is a debt limit that if we go beyond it. Here is an income limit that we're approaching as we're approaching the complexities of the case.
Thank you.
I thank you for your time.
Thank you. Our next speaker is Mark Smith.
Good afternoon. May it please the court. There's been a lot of great comments before me, so I won't repeat some of those because they took some of the words right out of me. But what I will say is that clearly the cap is a big issue, right, that has to be addressed. And by the way, I am a paralegal. I hope to be one of the first, right, to apply for this. But it's interesting, Ms. Landon stated that she didn't qualify to represent herself. I would be in that same boat based upon the current regulations. And about 20 years ago, I went through my own divorce and pro se'd it. That was the worst thing I could have ever done, right, to pro se my own divorce. But I was in that position where I couldn't afford the attorneys. And I think this is a great opportunity, obviously, and I hope we expand it continuously. But what I'd like to do is point out a couple of things that people haven't discussed that I think are important as we implement this program, because I think it's pretty clear we're going to implement the program from most of the comments. But when we talk about advocating for people, and I'm a business person too. I've had my own businesses. I've been a CFO. I have a lot more qualifications than just the legal, side of this. And one of the things that I identified in going through the documents was the division of fee. When you look at this from a business, and how do you allow me to do pro se work as well as, make an income, from this. It allows the division, you can do a fee sharing from what I understand the rules are as they're proposed, but it says except for the same law practice. So if I happen to be working with the attorney under the same umbrella, right, it has a restriction in there. I think there should be options so that we can advocate, so that we can bring in the attorney when we need to bring in the attorney, and have some unique business relationships that still follow the ethical rules, but we need to be creative in that so that we can promote and lower that cost, that entry point for most litigants to enter in the system. With also is the education requirements. Now, I could have 10,000 hours of experience, but if I didn't have a degree, I wouldn't qualify as the rules are currently written. Now, there is the one exception in item 8 that did say for 3 years, if you didn't have that qualification, we'd exempt it and allow you to apply. Again, same way, why do we have a $200,000 cap? Why do we say you have to have a degree, right? It should be the experience. It should be the person that you're looking at and the qualifications that get met. Obviously, there needs to be qualifications, the 1,500 hours, the 500 hours of other experience. That all makes sense. But it shouldn't be so anal because we have like the old boys club of the past, right, that we're going to inhibit you just because you don't follow the rules of the education system. The other thing was the ethics. I think the Colorado Center of Law and Policy stated it well in their description. It needs to be defined exactly what some of the restrictions would be. I'm a foster care parent, so I have to follow a lot of rules, right? And it's very clear that certain felonies, certain misdemeanors, right, disqualify you from, being able to do that. This program needs to have the same things, but at the same time, understand that hopefully we're still a state of rehabilitation, and if records get sealed, right, they shouldn't be used against you for the rest of your life. So I think the ethics rules need to accommodate that and allow those that have made mistakes, right, move forward.
When you say ethics, do you mean the character, any kind of character and fitness? Is that what you're?
Correct. Okay. So just because you had, let's say, a felony 25 years ago, that shouldn't automatically exclude you, unless obviously it met certain criteria, right, based upon what we're doing here. And that's my conclusion there.
Thank you.
Thank you.
Thanks.
Thank you.
Our next speaker is Todd Bovo.
Good afternoon, Your Honors. May it please the court. My name is Todd Bovo. I've been licensed for 15 years in Colorado, but I don't do family law. No disrespect to Mr. Bailey or Miss Landon, but I thought Mr. Smith was the best paralegal in the state. I have to frequently remind my clients that Mr. Smith is not an attorney because he speaks with such clarity. He defines the issues and he preps them with me. And we all know that very skilled paralegals do that in law firms all across the nation, and they help keep the engine running. I appreciate your time and consideration in this issue and helping the people that need it most. The reason why I'm here is in our jurisdiction, in the 18th jurisdiction, up to 76% of the litigants are unrepresented. As the chair of the Access to Justice in the 18th, I speak with Rick Morgan about this frequently. And for the last 6 years, we're on the front lines of the VPC clinic and talking with these people and filling out the forms and trying to solve problems. But the way that it's happening now, when they come in, we have 15 to 20 minutes to talk to them. We have 15 to 20 minutes to download forms or point them in the right direction. Frequently, I tell them, this is what you need to do. Go do this, and if you need any further help, come back. It's not working very well, especially in family law issues. They're not getting the kind of resources, or the clinics, due to the timing of the clinics, they're not able to come back in the right time frame. I think this is the greatest development and most progressive change in Colorado that will help people more than anything else that's ever happened. And I think that you giving the paralegals the opportunity to do this is going to change the lives. I see so many people that either refuse to address the issue, or they're not getting the access to justice. And I think the biggest change that should be implemented, and you brought this up, Justice Hood, is I think these paralegals eventually should be able to speak. This process is so intimidating. There's so much emotion. If this is modeled after the Student Practice Act with the right parameters, I think there will be more justice, and will take a lot of this away from the judiciary, sifting the parties apart from the emotion in it. And I think the limitations and the rules and the way to do that could be similar to how a plea is done. You understand that you have an opportunity to speak with an attorney, and you waive that opportunity. You have a licensed paralegal with you. You understand the implications, because there are going to be some accusations when paralegals don't put the right closing in. But if those barriers or those recommendations are met and those advisements are met in front before that happens, then I think that there's not going to be a lot of pointing back at the process. I mean, certainly paralegals are not lawyers. They're not trained, and they haven't gone through the licensing process. But what's happening now is unfortunate, and I think having anybody in the courtroom would be the greatest way to move these family law problems forward. And I think there could be some limitations on speaking, whether or not closings or directs, if that paralegal was questioning that particular client in order to stay on course, I think it would eliminate or decrease the judicial resources. So I've been excited about this. I think all of the committees in the Access to Justice, and Justice Hart, what you've done with this tour is so commendable. Thank you so much. And we're really excited for this program to begin and be a part of it. Thank you.
Thank you. Our next speaker is Colleen McManaman.
Good afternoon, Justices. Thank you for your time and attention to this matter. I'm a staunch advocate of the LLP program. As a family law paralegal for the better part of 30 years, a family law mediator for 13 years, I've supervised parenting time for over 8 years. I provide parent-coordinated decision-making services for over 7 years, and I'm also a CFI for over 5 years now. I've worked with wealthy families, I've worked with poor families, and all the walks of life in between. Through it all, I was continuously reminded that people want to be heard, and they want to understand where they need to go when they don't understand the situation they're in. The average person doesn't understand how to divorce or separate or be co-parents. Licensed legal paraprofessionals would be required to meet certain education requirements, as well as complete 15 hours of substantial law-related experience within 3 years, to include 500 hours of substantial family law experience. LLPs will be required to pass an exam on Colorado family law, demonstrating their sufficient skills and their core competencies, as well as a professional ethics exam. LLPs will have a wealth of knowledge and experience, such as myself, 30 years, as you know, regardless of what school you go to. It's the experience of working on some of these cases and with these families and with some of the best attorneys in Colorado that have taught me to minimize the drama, keep people focused, stay out of the weeds. Let's get you where you need to be. LLPs will have, I lost my train of thought, I'm sorry. Or I should say I lost my reading. LLPs will be more knowledgeable and understand simple DR cases better than new lawyers, and you've heard that talked about earlier today. LLPs will require to register annually as attorneys do and complete at least 30 credit hours every 3 years with 5 credit hours devoted to professional responsibility. So there will be eyes on LLPs at all times. According to the Denver Regional Council of Governments, the median household income in Broomfield, Douglas, and Arapahoe counties is somewhere between $83,000 and $125,000. The average monthly budget for a family of 4 in those same counties is between $8,190 and $9,706. The average equity in a home, pursuant to Colorado Realtors Association, for a homeowner of 5 years in Colorado is approximately $200,000, the current threshold. And you've heard arguments against that at this point. The average family cannot afford typical legal services for a divorce or an allocation of parental responsibilities, 2 of the most important decisions you'll ever make in your life. Attorneys are well educated and their expertise are not needed for simple divorce or APR, although they can handle it well, and I've seen many of them do it. LLPs will fill a void and add another tool for divorcing and separating families and parents. LLPs will not take clients away from attorneys. As you've heard earlier today, the demographics that we will be targeting are those just like myself and Laura Landon and others in this courtroom that really can't afford to hire the attorneys that we work for, but are lucky enough to have all the experience from those attorneys we've worked for. LLPs will offer their clients knowledge and experience that can help the families who otherwise would proceed pro se. And as you've heard earlier today, they're standing in the courtroom. They don't understand what they're doing. They don't understand how to proceed. The judges are limited in what they're allowed to do. The court staff is limited. And you have families hanging in the balance, the very crux of who any of us are standing in this room today. Mediators can draft MOUs, and as a mediator, I've drafted many MOUs. As a paralegal, I've drafted hundreds of parenting plans and separation agreements. The JDF forms are lacking, the detail needed and the teeth in the agreements needed to help these families go forward. There are many of them that use the forms, and then a year or 2 later, it's not working for them because they don't have simple information in it. Like, how do we communicate? Because they don't communicate any better now than they did pre-decree. And nobody's taught them or explained to them the tools that are available. Talking Parents, Our Family Wizard, do it in writing, don't use adjectives, be clear and concise. Nobody's had these conversations with them. Unfortunately, the ones they're having conversations with are their friends who are telling them about the horror stories and the worst ex-spouse they've ever had. So it's not helping. Sworn financial statements, I can't tell you how many people look at them and call and say, I don't understand. I'm going to end on that because it really is, one of my main concerns is the JDF forms and limiting LLPs to only completing JDF forms because they don't provide what's needed for these families to move forward with dignity.
Any questions? Thank you.
Thank you.
Our next speaker is Kyle Melchior.
May it please the court. My name is Kyle Melcher. My pronouns are he, him. I am a family law paralegal at Gendelman Klimas, and a fellow board member to the Rocky Mountain Paralegal Association. Despite the efforts that have been attempted to ensure affordable representation, Colorado is still experiencing an affordable representation crisis. In fact, most family law litigants cannot afford competent counsel in their cases when everyone should have the right to affordable representation. The LLP is one potential solution to this crisis that should be enacted by the Colorado Supreme Court. In most family law firms, it is us, the paralegals, who are on the front lines. It is us who interacts with the inquiring public and often see firsthand the barriers facing people of all backgrounds in obtaining competent and affordable help. It is us who often finds ourselves unable to offer an alternative option to people at a time when they most desperately seek it. When looking at the LLP, it is important to preface that the prospective LLP client is a person who is choosing between having the guidance of an LLP or having no representation at all. The LLP addresses a long-standing, unmet need that paralegals are intimately aware of and will not detract from the demand of family law attorneys. Looking to other regulated professions that deal with Coloradoans' most intimate and important issues, the medical field has long embraced a series of regulated professionals within their own scope of practice, who can provide limited services that need not be provided by a physician. Similar to the use of non-physician medical services, the LLP program will be able to provide timely legal care to those who need it most. Just like the medical practice, the success of this program will rely on the partnership between attorneys and LLPs. I have read all the comments submitted regarding the LLP program and respect the concerns that have been expressed. In summary, yes, change can be difficult, especially in a profession that is inherently reactive rather than prospective, such as the law. Many opponents of the program are concerned that LLPs cannot attain the same level of competence as an attorney. Most of the people in this room went to law school. As such, we know that the traditional law education teaches students the theory of law, not the practice of law. Many times, that attorney won't learn how to practice until they are trying their first case. It is not until an attorney spends time in practice that they learn how to interact with clients, appear in court, prepare a simple mediation statement, or even represent their client. At larger firms, associates often spend years without ever independently interacting with a client or going to court. Meanwhile, it is us, family law paralegals, who are entrenched in their clients' cases, drafting their financial disclosures, drafting their asset debt spreadsheets, preparing and filing their pleadings, and drafting separation agreements and parenting plans on day one. Non-attorney legal professionals, even absent any licensing process, often have more competence in these matters than entry-level attorneys. What the court may not know is often the paralegal is the one who trains the attorney in their first year. Any belief that a non-attorney cannot possibly attain the level of competence necessary to advise on routine, non-complex matters is not grounded in fact, but is grounded in fear, neither of which are legitimate objections to this important solution to the access to justice issue facing Colorado courts. In summary, paralegals and fellow non-attorney legal professionals may be the linchpin to solving Colorado's representation crisis, and I urge the court to implement the LLP program, which is an important part to promoting the access to justice in Colorado courts. Thank you.
Thank you. Our next speaker is Stephanie Trujillo.
Good afternoon, Your Honors. Thank you for your time this afternoon. My name is Stephanie Trujillo. I am the current president of the Rocky Mountain Paralegal Association, and I have had the honor of serving on the PALS Outreach and Communications Committee. I've been a paralegal for about 20 years. I am here representing the paralegals of our association, a few of which you have already heard from today. The Rocky Mountain Paralegal Association is a nonprofit that will be celebrating our 50th anniversary next year. We have approximately 250 members, most of which are paralegals. Our purpose and objectives are to serve as a leading voice of the paralegal profession, promote continuing legal education, training, and support to paralegals through programs, specialty sections, seminars, and other educational media. We encourage pro bono and other community service involvement, and we provide a forum for the exchange of viewpoints on matters of professional interest. We will continue doing this as we hope the LLP plan moves forward. I think it's important for the court to know that we do have a family law section with paralegals who are interested in pursuing an LLP license. Many of these paralegals who want to see the LLP program move forward are employed at family law firms here in Colorado. Because of the high level of regard they have for the attorneys they support, they want to respect the fact that some of the firms and the attorneys are not in support of the program. So they are not speaking up. As has been previously stated by other speakers, this would be a natural progression for these individuals, and they are more than willing to provide their services to our community. I don't want to get too much into the need for LLPs because I think the data is pretty clear, and we appreciate the fact that the court has already recognized the need. With respect to the implementation plan, which we have already spoke a lot about today and discussed a lot about, there is a concern regarding how we evaluate whether or not an LLP can take a case based upon the initial determination of net marital assets, of dissolution or civil union matters, and also what the income and or combined parental income threshold should be for APR matters. Well, there doesn't appear to be these thresholds to measure the complexity of a matter in other states. I do think we need to kind of flesh this out a little bit more. And as we are doing so, I think we need to keep in mind the alarming rate at which our housing market grew and the cost of living here in Colorado, which is changing raises and other pay adjustments that employers must give to keep up with competitors and industry standards. I will end with this. RAMPA is extremely excited for the implementation of this program, and we hope to be the leading voice of the LLP profession. Thank you.
Thank you.
Thank you.
And our next and final speaker is Jessica Yates.
Took me a minute. She said Rampa. I heard Grandpa. Sorry.
So, Ms. Yates, are you going to tell us who the best paralegal in Colorado is?
I'm also not going to tell you who the best attorney is in Colorado. So may it please the court, I'm here today mostly to answer questions because I've lost my voice. I have tested for COVID negative twice, so I don't think I bear a threat to anyone, but I did want to be responsive to some of the questions that had been posed earlier. One was just, will this make an impact? So when we look at what other states have done in this area, such as Utah and Arizona and Washington, as well as Minnesota, slightly different because they're on a pilot program, really they tend to be slow to launch, which is great because it gives us time to build the infrastructure needed to support a licensed paralegal or paraprofessional program. But if you take, say, 20 of them coming into the program at any given year, which is about the comparable to what states have experienced. And you take, for example, I was just chatting with Maha about her caseload on any given year and kind of making some guesstimates because she does both limited scope and also full-scale representation. Let's say it's 80 clients a year. So all of a sudden, 1,600 people get representation in a given year who are going to go it alone. And then you double that the next year because if you can double the program to 40 licensed paraprofessionals, that's 3,200 people all of a sudden being able to get representation when they were going to go alone. And that makes a difference over time. It makes a difference to the courts. It makes a difference to the people involved. It makes a difference to our system of justice. We also have reason to believe that paralegals will come to this program. You're hearing from some of them today. We talked to the program coordinator at Arapahoe Community College. Their paralegal program costs about $9,000, and it's an ABA accredited program. So the ABA actually can accredit these programs, and they really believe that the core competencies that the licensure and qualifications working group developed are very much consistent with the type of training that they offer. So that had been my worry. Like, are we asking the impossible in the paralegal exam? Is this something that's just not going to be doable? And I am being told by the community colleges that offer this training that this is doable and it's a fair ask. And they will come ready to practice. Now, a lot of the fears I think that are out there of, oh my gosh, these people, they don't know what they're doing. And of course, we all know that we came to licensure and admittance and took our oath not knowing what we were doing. Our system on paper for lawyers is crazy. This idea that we should ever just get the oath of admission one day and take a, say, complicated personal injury case the next day would be nuts. I don't see that in my office. Why not? We have developed in the background a system to protect against that. So we have the rules of professional conduct. We have the professionalism class. And people coming out of law school know that they really shouldn't go out and just hang their own shingle on day one, but instead that they should associate with attorneys or go through the Legal Entrepreneurs for Justice program so that they're ready to hang their own shingle, or go get CBA training so that they can do that. Come to our trust account school. That is the reality of the way people approach the practice of law. And we have no reason whatsoever to think that LLPs would approach it any differently. So one of the questions that will be posed to this court from a public protection standpoint, and that's really kind of how I'm wearing my hat today, is what is needed given the realities of what would occur on a market-based perspective and also just from a rule perspective. So one of the rules that you were provided, it starts on page 28 of that big attachment one packet, and that's the one that really is the jurisdictional piece. What can these people do? What's their limited scope of practice? And I definitely encourage the court to spend some time thinking about the interplay between that rule and your basic competency rule and scope of practice rules and the ethics rules that would apply to these individuals. Because most states have decided instead to just require that they be competent, just kind of like how attorneys are, and not have nearly the level of detail in the scope of practice. That's an option. Colorado could pursue that. I am supporting at least some sort of jurisdictional limitations. I think that could be helpful. I do respect the questions of if they go to court, which we're kind of hoping some of this stuff just gets mediated. But if they go to court, what can they do? And the rule as drafted does allow them to answer factual questions from a judge. That is in there. So they wouldn't have to be completely muted. But I do think that some jurisdictional limitations probably are appropriate given that they aren't a full scope JD. Whether we have hit the right balance, I don't know. I look forward to the feedback from the court. We've heard some of that feedback today. I'm happy to answer any questions.
I feel like it would just be mean to ask you questions.
Yes, and I do have a quick one, and I'm sorry to force you to speak further, but you probably heard some of the exchanges about giving the ability of the LLPs to stand up in court and speak. Do you have thoughts or concerns about that? And I'm thinking about this from your perspective as a regulator of the practice of law. At what point do you cross that threshold? Do you have any thoughts on that, I guess?
I actually would be comfortable with a little bit more that's in the rule and allowing them to stand up and speak and address the court about why are we here today? What is the relief that my client is seeking? What are we trying to do? I would have more concerns about examining witnesses. I think that is something that is actually pretty technical and could get, things could get a little crosswise in the court, or putting on an expert witness. I think that could be fairly something that shouldn't be done. We're trying to introduce evidence over objections.
Thank you.
Yeah.
In hearing the thoughts today about complexity, to me, no pun intended, that's the complex question here, is how do we define that? But After hearing statements today and your experience in this, what are your thoughts?
Yeah, I think that right now the rule as drafted does have some good boundaries on complexity. I am not sure, with respect to some of what we heard, like, does it, for example, remedial contempt, is it necessarily always complex? I don't know that it necessarily is. I'm not sure that some of those boundaries would change. But the dollar thresholds, I will tell you, that does give me some angst. And I think there's some merit to thinking about not having any dollar thresholds, in part because it's not necessarily a great measure of complexity, but also I do worry about it being this collateral point of whether the representation can occur when not all of the facts are on the table. And I think that's the part that, can we really expect these practitioners to fairly evaluate whether they can take on a representation when that person walks in the door and they just might not have all the information? I mean, even if they're relying in good faith on their client for that.
Thank you.
That's part of what makes defining complexity and setting boundaries around it so challenging, right? How do you define it? How do you include all of the things you should include without maybe including things you shouldn't? Or, I don't know. I wonder if, we're going to be relying, if we approve this, we're going to be relying on LLPs to exercise their judgment and to tell people, you know what, you need a lawyer, right? So should we, and I'm just thinking out loud, should we rely on them to also say, this is too complicated, I don't know enough about this, you need a lawyer, right? I can't help you.
Yeah, and I think we should rely on them. I think it might be a little bit easier for them, right now, the way the proposed ethics rules are drafted for them, is they would have to advise the client, I'm an LLP, not a lawyer, so there's some things I can't do. And if this court were to adopt limitations on, say, court appearances and the ability to handle hearings, one of the things that they would be obligated to do is to say, what you're telling me, in one hypothetical, is this is going to head to a hearing, and I'm not going to be able to help you. So you could pay me to help you with the paperwork, but you're also going to have to hire a lawyer. So that scope of practice limitation will then dovetail into what they have to advise the client on day one, because it becomes a real ethics problem if the client is misled into believing that this practitioner could help them with a full panoply of everything involved in their case, when in fact the rules on paper would tell them that they can't.
Ms. Yates, good afternoon. I know I've asked you about this in other settings, but I want to give you a chance to just publicly deal with it relating to what we're talking about. Could you address the liability risk issue? Say the LLP doesn't do what they're supposed to do and they get in over their head and they commit what would be malpractice if a lawyer did it.
Sure. Yes, and so under our proposed rules, if the LLP was in fact dishonest in this circumstance, the client would actually qualify for the Client Protection Fund. But I think your question goes to the legal malpractice, which is just not following the standard of care. I do believe, based on what other states have experienced, that they would be able to acquire malpractice insurance. I know one of the comments is, should they be required to get malpractice insurance? And that is something that lawyers in Colorado currently are not required to do. I do think it'd be interesting for insurers to look, depending on what the court approves, the scope of practice, because insurers will tell all of us just sort of generally that they price policies depending on level of risk. So some of it is just, lawyers' claim experiences, studying, et cetera, but also what's their practice area and their scope of practice. The scope of practice that we're talking about doesn't lend itself to a whole lot of money getting lost. In kind of a worst case scenario, there's just not that much on the table. And so from an insurance perspective, they're going to look at these people as generally not giving rise to much of any claims. And I think that, so if the court were to require malpractice insurance, it would be a disparity in terms of attorneys. But from a market analysis perspective, I don't think it's a huge barrier to entry. I think they'd be able to manage it.
Thank you. I just wanted to give you the chance to say that in a public setting.
Sure, of course.
Can I ask one final question? I'm thinking out loud here. Was there any kind of study on what type of malpractice claims there are in domestic cases to help us kind of try to define what complex means? Does that make sense?
It does, and in terms of claims made versus claims paid, I guess would be another question.
Right.
I don't think that we have studied that specifically. I think there have been general studies about areas of practice that do tend to generate claims. Trust and estates is kind of a big one because of how things can go sideways. In really complex family law cases, but it tends to be high asset cases that actually sort of generate the most sort of issues that, that's really where I think things have gone sideways for one party and they feel that their attorney's to blame. But the kinds of stuff that, when you look at what insurance companies talk about, they talk about, say, conflicts issues and fiduciary duty and stuff like that, which just conflicts aren't going to be a big deal in these types of cases, quite frankly. I mean, that's, that tends to be organizational clients that happens.
I just asked that because I know that like the insurance industry is known about brain development far longer than we've known about, CAT scans and things like that. They were able to identify it based on actuarial things. So I didn't know if they could define some of the complexity. But.
Yeah, the stuff that I've seen hasn't really related to individual family law cases. It's related to more organizational clients or big asset cases.
All right, thank you.
Yeah.
Thank you.
Yeah, thanks.
Thank you.
All right. Thanks to all of you who submitted written comments, and thanks to all of you who have appeared here today to speak or to listen to the speakers. The court greatly appreciates all of your input. You've given all of us a lot to think about. We're going to go ahead and take the advisory committee's recommendation under advisement. And with that, I'm going to turn matters back over to the Chief Justice.
All right, and let me just echo, I want to say thank you to everybody who came in and spoke, and for those of you who were nervous, you did an excellent job. I very much appreciate it, and we will be in recess. Have a good rest of your day. Or is it